This is the revised POEA rules and regulations, governing the recruitment and employment of land-based overseas Filipino workers of 2016. Part 1. General Provisions. Rule 1. Statement of Policy. It is the policy of the administration. 1. To uphold the dignity and fundamental human rights of overseas Filipino workers, and promote full employment, and equality of employment opportunities for all. 2. To protect every citizen desiring to work overseas, by securing the best possible terms and conditions of employment. 3. To allow the deployment of overseas Filipino workers, only in countries where their rights are protected. 4. To provide an effective gender-sensitive mechanism, that can adequately protect and safeguard the rights and interest of overseas Filipino workers. 5. To educate overseas Filipino workers, through dissemination of information, not only of their rights as workers, but also of their rights as human beings, as well as instruct and guide the workers on how to assert their rights, and provide available mechanisms to redress violations of their rights. 6. To ensure careful selection of Filipino workers for overseas employment, in order to protect the good name of the Philippines abroad. 7. To institute a system to guarantee that overseas Filipino workers possess the necessary skills, knowledge and experience for their overseas jobs. 8. To recognize the participation of the private sector, in the ethical recruitment and placement of overseas Filipino workers, to serve national development objectives. 9. To regulate private sector participation in the recruitment and placement of workers for overseas employment. 10. To support programs for the reintegration of returning overseas Filipino workers into Philippine society. 11. To pursue, with the active participation of the private sector, the creation of an environment, conducive to the overseas employment program, in order to maximize opportunities for employment generation, facilitation, enhancement and preservation. 12. To promote and support the establishment of a shared government information system on the overseas employment program, using a computer database to allow verification and free flow of data exchanges. 13. To formulate and implement, in coordination with appropriate entities concerned, a system of promoting and monitoring the overseas employment of Filipino workers, taking into consideration their welfare and the domestic manpower requirements. 14. To recognize recruitment agencies, non-governmental organizations, trade unions, workers' associations, and other stakeholders, as partners of the state in the protection of overseas Filipino workers and the promotion of their welfare, and to cooperate with them in a spirit of trust, mutual respect and tripartism. And 15. To strengthen conciliation and mediation, as primary modes of dispute resolution. Rule 2. Definition of terms. For purposes of these rules, the following terms are defined as follows. 1. Accreditation. Refers to the grant of authority by the administration to a foreign principal or employer, to recruit and hire Filipino workers through a licensed recruitment agency for overseas employment. 2. Administration. Refers to the Philippine Overseas Employment Administration or POEA. 3. Administrator. Refers to the administrator of the POEA. 4. Authentication. Refers to the attestation by the Philippine Consular Office or competent authority, of the genuineness of the signature appearing on the document, for the purpose of identifying a specific document, and giving credence to the official act of the notary public or certifying officers thereon, for use, if and when required, as an instrument of evidence in a foreign country. 5. Contracted worker. Refers to an overseas Filipino worker with employment contract or offer of employment already processed by the POEA for overseas deployment, whether as an agency hire or a direct hire. 6. Derogatory record. Refers to the resolution on the finding of probable cause by the Department of Justice, for illegal recruitment or for other related crimes or offenses, or a licensed recruitment agency whose license had been cancelled or revoked by the POEA, including its proprietors, partners or officers, directors, and employees responsible for the commission of the crime or offense. This includes a certification from the NBI, that the person has a derogatory record. 7. DOLE. Refers to the Department of Labor and Employment. 8. Domestic worker. Refers to any person engaged in domestic work. It is work performed in, or for a household, within an employment relationship. 9. DFA. Refers to the Department of Foreign Affairs. 10. Documentation cost. Refers to the actual costs incurred in the documentation of an applicant worker, in relation to his or her application for overseas employment. 11. Employer. Refers to a person, partnership, or corporation, that directly signs an employment contract, and employs, and pays salaries and benefits of workers, as well as repatriates hired overseas Filipino workers. 12. Employment contract or offer of employment. Refers to an individual written agreement between the principal or employer, and the worker who is hired through a licensed recruitment agency or through the administration, containing the minimum terms and conditions of employment as provided under these rules. 13. Foreign Placement Agency or FBA. Refers to any single proprietor, partnership or corporation duly licensed in the host country, to engage in the recruitment of foreign workers for placement with their clients. 14. Foreign Service Contractor or Staffing Agency. Refers to any single proprietor, partnership or corporation duly licensed in the host country, to recruit foreign workers for its projects, or for the projects of its clients, and remains as the employer of the deployed workers. 15. Jobs Fair. Refers to an employment facilitation service, that is a venue for licensed recruitment agencies, to advertise job vacancies, for the purpose of recruiting qualified job applicants. 16. Job site. Refers to the country or territory of employment, as indicated in the POEA approved employment contract. 17. Joint and several liability. Refers to the nature of liability of the principal or employer and the licensed recruitment agency, for any and all claims arising out of the implementation of the employment contract involving overseas Filipino workers. It shall likewise refer to the nature of liability of partners, or officers and directors with the partnership or corporation, over claims arising from an employer-employee relationship. 18. LAC. Refers to the Labor Assistance Center of the POEA located in international airports and other exit points. 19. LOA. Refers to the letter of authority issued by the administration, authorizing an accredited foreign principal or its representative or representatives, to participate in the screening, interview and selection of applicants for their approved job orders, in places outside the registered business address of the licensed recruitment agency, as indicated in the Special Recruitment Authority. 20. License. Refers to the document issued by the Secretary or his or her duly authorized representative, authorizing a person, partnership or corporation to operate a recruitment agency. 21. Licensed Recruitment Agency. Refers to any person, partnership or corporation, duly authorized to engage in the recruitment and placement of workers for overseas employment. 22. Master Employment Contract. Refers to the model employment agreement, submitted by the principal or employer as defined under these rules, which contains the terms and conditions of employment of each worker to be hired by such principal or employer, with such contract to be duly verified by the POLO, or authenticated by the Philippine Embassy or Consulate, and approved by the POEA. 23. NBI refers to the National Bureau of Investigation. 24. NLRC refers to the National Labor Relations Commission. 25. Non-licensee refers to a person, sole proprietor, partnership or corporation, without a license to engage in the recruitment and placement of overseas Filipino workers, or a licensed recruitment agency whose license has been revoked, cancelled, expired or delisted from the roll of licensed recruitment agencies. 26. Overseas Employment Certificate or OEC refers to the document issued to overseas Filipino workers, which serves as proof that the worker has been processed by the administration or POLO. 27. Overseas Filipino worker or migrant worker refers to a person who is to be engaged, is engaged, or has been engaged in a remunerated activity, in a state or country of which the worker is not a citizen. A person to be engaged in a remunerated activity refers to an applicant worker, who has been promised or assured employment overseas. 28. OWA refers to the Overseas Workers Welfare Administration. 29. PAOS refers to the Post-Arrival Orientation Seminar. 30. PDOS refers to the Pre-Departure Orientation Seminar. 31. PEOS refers to the Pre-Employment Orientation Seminar. 32. Placement fee refers to any, and all amounts charged by a recruitment agency, from a worker for its recruitment and placement services, as prescribed by the Secretary of Labor and Employment. 33. POLO refers to the Philippine Overseas Labor Office. 34. Principal refers to the employer, or to a foreign placement agency, or a foreign service contractor or staffing agency, hiring Filipino workers for overseas employment through a licensed recruitment agency, or through the administration. 35. POCB refers to the Philippine Overseas Construction Board. 36. Recruitment Agreement refers to an agreement by and between the principal and the licensed recruitment agency, or the administration, defining their rights and obligations on the recruitment and employment of workers. 37. Recruitment and Placement refers to any act of canvassing, enlisting, contracting, transporting, utilizing, hiring or procuring workers, and includes referring, contracting services, promising or advertising for employment abroad, whether for profit or not. 38. Registration of worker refers to the act of entering in the official records of the administration, the names of overseas job seekers and contracted workers. 39. Regular or documented overseas Filipino worker refers to 1. A. Who possesses a valid passport, and appropriate visa, or permit to stay and work in the receiving country. And B. Whose contract of employment has been processed by the POEA or the POLO. 40. Returning worker or balik manggagawa refers to an overseas Filipino worker, who has served or is serving his or her employment contract and is A. Returning to the same employer in the same job site. Or B. Returning to the same employer in a new job site. It shall also include an overseas Filipino worker, who has started employment with a new employer and is returning to the said employer. 41. SEC refers to the Securities and Exchange Commission. 42. Service fee refers to the amount paid to a licensed recruitment agency, or to the administration, in the case of government to government hired workers, by foreign principals or employers, as payment for actual services rendered, in relation to the recruitment and placement of workers. 43. Special Recruitment Authority refers to the authority granted to a licensed recruitment agency, to conduct recruitment outside of its registered business address. 44. Standard Employment Contract refers to the POEA prescribed contract containing the minimum terms and conditions of employment. 45. TESDA refers to the Technical Education and Skills Development Authority. 46. Underage migrant worker refers to one who is below the minimum age requirement for overseas employment, as prescribed by the POEA Governing Board. This is Part 2 of the revised POEA Rules and Regulations, governing the recruitment and employment of land-based overseas Filipino workers of 2016. Licensing and Regulation. Rule 1. Private sector participation in the Overseas Employment Program. Section 1. Participation of the private sector. The private sector shall participate in the recruitment of Filipino workers for overseas employment, in accordance with these rules, and any subsequent guidelines that may be issued by the POEA Governing Board and the Administration. Section 2. Who may participate? Required capitalization. Any Filipino citizen acting as a sole proprietor or a partnership, or a corporation at least 75% of the authorized and voting capital stock, of which is owned and controlled by Filipino citizens, may engage in the business of recruitment and placement of Filipino workers. The sole proprietor and partnership shall have a minimum capitalization of 5 million pesos and a minimum paid-up capital of 5 million pesos in case of a corporation. Those with existing licenses shall, within 4 years from effectivity hereof, increase their capitalization or paid-up capital, as the case may be, to 5 million pesos at the rate of 750,000 pesos every year. Section 3. Who are disqualified? The following persons and entities are disqualified to participate or engage in the recruitment and placement of workers for overseas employment. A. Travel agencies and sales agencies of airline companies. B. Officers or members of the board of any corporation, or partners in a partnership, engaged in the business of a travel agency. C. Corporations and partnerships, where any of its officers, members of the board or partners, is also an officer, member of the board or partner of a corporation or partnership, engaged in the business of a travel agency. D. Individuals, partners, officers or directors of an insurance company, who make, propose or provide an insurance contract under the compulsory insurance coverage for agency-hired overseas Filipino workers. E. Sole proprietors, partners or officers and members of the board with derogatory records, such as, but not limited to the following. 1. Those convicted, or against whom probable cause or prima facie finding of guilt is determined by a competent authority, for illegal recruitment, or for other related crimes or offenses committed in the course of, related to, or resulting from, illegal recruitment, or for crimes involving moral turpitude. 2. Those agencies whose licenses have been revoked for violation of RA 8042, the Migrant Workers and Overseas Filipinos Act of 1995, as amended, PD 442, the Labor Code of the Philippines, as amended, and RA 9208, the Trafficking in Persons Act of 2003, as amended, and their implementing rules and regulations. 3. Those agencies whose licenses have been cancelled, or those who, pursuant to the order of the administrator, were included in the list of persons with derogatory record for violation of recruitment laws and regulations. And F. Any official or employee of the DOLE, POEA, OEA, DFA, DOJ, DOH, BI, IC, NLRC, TESDA, CFO, NBI, PNP, Civil Aviation Authority of the Philippines or CAAP, international airport authorities, and other government agencies directly involved in the implementation of RA 8042, as amended, and or any of his or her relatives within the fourth civil degree of consanguinity or affinity. Rule 2. Issuance of license. A. Application. Section 4. Pre-qualification requirements. Any person applying for a license to operate a recruitment agency, shall file a written application with the administration, together with the following requirements. A. Business name certificate issued by the Department of Trade and Industry or DTI, in the case of a single proprietorship, or a certified copy of the Articles of Partnership, or Articles of Incorporation duly registered with the SEC, in the case of a partnership or corporation. B. Proof of financial capacity. 1. Bank certificate showing a deposit of at least 5 million pesos, with authority to examine the bank account. 2. Duly filed income tax returns or ITR for the last 2 years of the proprietor, partners, members of the board of directors and major stockholders of a corporation, and official receipts showing payment of income tax. And 3. Proof of sources of investment. C. Proof of existence of new market. 1. POLO verified and or consulate authenticated recruitment or service agreement or RASA, duly concluded by the applicant and the new principal or employer. For this purpose, a new principal or employer refers to a principal or employer which has never been accredited, or registered with any licensed recruitment agency or with the administration, and has been existing for at least a year. Provided, that in the case of a foreign placement agency, its client employer or employers, must be identified and must not have been accredited with any licensed recruitment agency, or with the administration. 2. Employer's profile to include A. Valid business license or commercial registration of the principal or employer, with English translation. B. Information on business activities. C. Number of years in operation. And D. Number of workers. D. Proof of possession by the sole proprietor, managing partner, president or chief executive officer, as the case may be, of a bachelor's degree, or at least 4 years' experience in human resource management, or experience in heading or managing a manpower business. E. Valid clearances from the NBI and the Anti-Illegal Recruitment Branch of the Administration, for the proprietor, partners, and all members of the board of directors of the applicant agency. If a member of the board is a foreign national, a duly authenticated police clearance from his or her country of origin, shall be required. F. A duly notarized undertaking by the sole proprietor, the managing partner, or the president of the corporation, stating that the applicant shall 1. Negotiate for the best terms and conditions of employment for the workers. 2. Select and deploy only medically fit and competent workers, as tested by the employers, or certified by TESDA, or by other competent authority. 3. Provide orientation to the workers on recruitment procedures, as well as the country profile, and the working and living conditions, and other relevant information about the host country and work site. 4. Obtain compulsory insurance coverage for its hired workers, for the duration of the contract of employment, at no cost to the workers. 5. Provide the worker a copy of the contract upon signing, and provide the OEC upon issuance. 6. Guarantee that there is no officer or employee of the recruitment agency, related within the fourth civil degree of consanguinity or affinity, to any official or employee of any government agency engaged, directly or indirectly, in the implementation of RA 8042, as amended. 7. Assume full and complete responsibility, for all claims and liabilities, which may arise in connection with the use of the license. 8. Assume joint and several liability with the employer, for all claims and liabilities, which may arise in connection with the implementation of the contract, including but not limited to unpaid wages, death and disability compensation, and repatriation. 9. Assume full and complete responsibility for all acts of its officers, employees and representatives done in connection with recruitment and placement. 10. Adhere to the ethical standards as prescribed in the Code of Conduct for Ethical Recruitment, as endorsed by recruitment industry associations and the administration. And 11. Guarantee compliance with existing labor and social legislation of the Philippines, and of the country of employment of the recruited workers. G. In case of a corporation or partnership, a duly notarized undertaking by the corporate officers and directors, or partners, that they shall be jointly and severally liable with the corporation or partnership, for claims and or damages that may be awarded to the workers. H. List of all officials and personnel, involved in recruitment and placement, together with their appointment, signed biodata and 2 copies of their passport-sized pictures, as well as their clearances from the NBI and their individual affidavits, declaring that they have no conviction or pending criminal case for illegal recruitment, or case involving moral turpitude. I. Certificate of attendance of the sole proprietor, managing partner, president, chief executive officer and/or operations manager, in a pre-licensing orientation seminar or PLOS. J. Flowchart detailing step-by-step recruitment procedures, documentary requirements, briefings and orientations required, authorized fees and costs, deployment time frames, and the responsible officer or officers, and process cycle time for every phase of the process. K. 4-year business plan detailing financial, market and operational viability, including projected income and a risk management plan. Section 5. Payment of filing fee. Upon receipt of the complete requirements for application, the administration shall require payment of a non-refundable filing fee of 25,000 pesos and submission of proof of payment thereof. Section 6. Panel interview. The proprietor, partners and members of the board of directors, including the major stockholders, shall undergo a panel interview, to ascertain their qualifications, and fulfillment of the requirements under Rules 1 and 2, Part 2 of these rules. Section 7. Decision on the application. The administration shall notify the applicant in writing, of the decision on the application, within 3 working days after interview. Section 8. Grounds for denial of application. An application for license shall be denied, when the applicant fails to satisfy any of the requirements, or gives any false information or documents. Section 9. Submission of post-qualification requirements. Upon receipt of the notification, the applicant shall submit the following post-qualification requirements, prior to the issuance of the provisional license. A lease contract for an office space, measuring at least 100 square meters, or proof of building ownership, that will be used as an office, or an identified portion thereof, measuring at least 100 square meters. B. An office layout, providing and clearly delineating adequate spaces, that will serve as receiving area, interview room, administrative and finance area, conference or training room, and an executive office. C. An inventory of office equipment and facilities, which at the minimum, shall include the following. 1. Office furniture, such as tables and chairs for the president and other officers and employees, as well as similar furniture for the receiving area, interview room and conference or training room. 2. Secured filing cabinets. And 3. Office equipment which shall, at the minimum, include 2 computers, computer printer and scanner, photocopying machine, fax machine, landline telephone, internet connection, and multimedia equipment, for example, LCD projector, and other similar audiovisual equipment. D. Organizational chart, indicating the duties and responsibilities, and names of officers and staff, which shall, at the minimum, consist of the President, Chief Executive Officer, recruitment and/or documentation officer, accountant or bookkeeper, cashier, and liaison officer. E. Payment of license fee of 100,000 pesos. And F. An escrow agreement with a bank authorized by the Bangko Sentral ng Pilipinas, to handle trust accounts, with deposit in the amount of 1 million pesos. The escrow deposit shall answer for all valid and legal claims, arising from contracts of employment and violations of the conditions for the grant and use of the license, including fines imposed by the administration. The escrow shall likewise guarantee compliance with prescribed recruitment procedures, rules and regulations, appropriate terms and conditions of employment, and relevant issuances of the DOLE. The escrow deposit shall not be sourced from the capitalization requirement. Section 10. Assessment prior to issuance of license. The administration shall assess the applicant's compliance with paragraphs A, B, and C, of the preceding section. The Labor Laws Compliance Officer or LLCO, shall determine the size of the office space, and the existence of the facilities and equipment as shown in the applicant's floor plan and inventory of equipment. The assessment shall be conducted in accordance with the provisions of Rule 3, Part 2 of these rules. B. Provisional license. Section 11. Issuance and validity of a provisional license. Within 5 working days from satisfaction of the post-qualification requirements, the administration shall issue a provisional license, which shall be valid within a non-extendable period of 2 years from date of issuance. Section 12. Prohibition. The agency granted with a provisional license shall not deploy domestic workers during the validity of the provisional license. See regular license. Section 13. Application for upgrading of provisional license to a regular license. Upon application, a provisional license may be upgraded to a regular license at any time during its validity, upon deployment of 100 workers to its new principal or principals, and upon submission of the following. A. Quality Management System or QMS Manual, defining the scope of the agency's quality management system that includes, among others, the quality policy and objectives, organizational structure and management responsibilities, and documented recruitment and deployment processes. B. Updated bank certificate stating that the escrow deposit remains at 1 million. C. Certificate of no pending case, or any substantiated adverse report during the validity of the provisional license. D. Certificate of attendance to the Continuing Agency Education Program or CAEP of all its officers and staff. And E. Latest audited financial statement. Section 14. Validity of a regular license. The regular license shall be valid up to the full term of 4 years from the date of issuance of the provisional license. The application for upgrading of the provisional license shall be filed within 3 months before the expiration of the provisional license. D. Renewal of license. Section 15. Renewal of license. A licensed recruitment agency should submit an application for the renewal of its license within 3 months before the expiration of its license. The application shall be supported by the following documents. A. Updated DTI registration in case of sole proprietorship, or general information sheet in case of partnership and corporation. B. Renewed or new escrow agreement with a commercial bank authorized to handle trust accounts by the Bangko Sentral ng Pilipinas, supported by a bank certification. Provided that, if during the renewal, the applicant has pending recruitment violation case or cases before the administration, an additional escrow deposit shall be required in accordance with the following schedule. 1 to 5 pending cases, the additional escrow deposit is 50,000 pesos per case. 6 to 10 pending cases, additional escrow deposit of 75,000 pesos per case. If there are 11 or more pending cases, the additional escrow deposit is 100,000 pesos per case. The total escrow deposit shall, in no case, exceed 2 million pesos. Provided, further, that, if in the succeeding renewal, the licensed recruitment agency has no pending case, the administration shall allow the withdrawal of the additional escrow deposit. C. Duly filed latest audited financial statements and income tax returns of the licensed recruitment agency. In case the equity of the licensed recruitment agency is below the minimum capitalization requirement, it shall be given 30 days from release of the renewed license, to submit an SEC certification on capital infusion, otherwise the license shall be suspended until it has complied with such requirement. D. Clearances from the NBI and the Anti-Illegal Recruitment Branch of the sole proprietor, partners, members of the board of directors, officers, and personnel. And E. Valid certificate of compliance, with general labor standards, and valid certificate of compliance with occupational safety and health standards. The administration shall only accept applications with complete requirements, based on the checklist for renewal of license. No application shall be accepted after the date of expiration of the license. Section 16. Action on renewal of license. The administration shall evaluate the application within 5 working days from receipt of such application. The license remains valid, until the application shall have been finally acted upon. E. Escrow deposit. Section 17. Maintenance of escrow deposit. A licensed recruitment agency shall maintain at all times its escrow deposit in the minimum amount of 1 million pesos. In case the licensed recruitment agency is required an additional escrow pursuant to Section 15, it shall maintain the escrow deposit of 1 million pesos plus the additional escrow. In case the escrow deposit has been garnished, the licensed recruitment agency shall replenish the escrow deposit, within 15 days from receipt of the notice to replenish escrow deposit. Failure to comply with such notice, will result in the suspension of the license of the recruitment agency. Within the same 15-day period, the licensed recruitment agency may explain why it should not be suspended for such failure to comply. The administration shall ensure compliance with the increased escrow deposit as provided in this rule. Section 18. Monitoring compliance with conditions for the issuance of the license. The administration shall monitor the compliance of licensed recruitment agencies, with the conditions for the issuance of license, recruitment laws, rules and regulations on the use of license, and general labor standards, and occupational safety and health standards, in coordination with the Dole Regional Office. The administration shall suspend or revoke the license of a recruitment agency, for failure to maintain the required qualifications or conditions for the issuance of a license as provided in this rule. Section 19. Release of deposit in escrow. The deposit in escrow of a licensed recruitment agency, that voluntarily surrenders its license or has not renewed its license, shall be released upon submission of the following. A. Copy of the duly executed or signed escrow agreement. B. Bank certification on the status of escrow deposit. C. Certificate of no pending case from the NLRC. D. Clearance from the adjudication office. E. Notarized board resolution or partnership resolution duly received by the SEC, on the decision to withdraw escrow deposit, indicating the name of the person to process and receive the check representing the escrow deposit. And F. Surety bond equivalent to the amount of the escrow deposit, valid for 4 years from expiration of the license, if applicable. F. Common Provisions. Section 20. Derogatory record after issuance or renewal of license. The license of a single proprietorship or a partnership shall be suspended, until cleared by the administration, should any derogatory record as provided in Section 3 herein be found to exist, against the single proprietor or any or all of the partners, as the case may be. The appointment of any officer or employee of any licensed recruitment agency may be cancelled or revoked by the administration at any time, with due notice to the licensed recruitment agency concerned, whenever said officer or employee is found to have any derogatory record. Section 21. Non-transferability of license. No license shall be used, directly or indirectly, by any person other than the one in whose favor it was issued, nor at any place other than that stated in the license, nor may such license be transferred, conveyed or assigned to any other person or entity. Section 22. Revocation of license of sole proprietorship. The license of the sole proprietorship shall automatically be revoked upon the death of the sole proprietor. The next in rank officer of the agency shall, within 10 days, report such death to the administration. Failure to report shall automatically include such next in rank officer in the list of persons with derogatory record. Section 23. Revocation of license of a partnership due to death or withdrawal of partner. The license of a partnership shall be automatically revoked upon the death or withdrawal of a partner, which materially interrupts the course of business, or results in the actual dissolution of the partnership. The surviving partner or partners shall, within 10 days, report such death or withdrawal to the administration. Failure to report shall automatically include the surviving partner or partners in the list of persons with derogatory record. Section 24. Upgrading, merger or consolidation of licensed recruitment agencies. The upgrading, merger or consolidation of licensed recruitment agencies shall be undertaken in accordance with the regulations of the SEC, without prejudice to the determination by the administration of the qualifications of the new partners or directors. The upgraded licensed recruitment agencies, the surviving corporation, or the new corporation, as the case may be, shall inform the administration of such changes within 30 days from confirmation by SEC of such upgrading, merger or consolidation. Section 25. Change in the composition of partners or board of directors. The licensed recruitment agency shall notify the administration of every change in the composition of the partnership or board of directors, within 30 calendar days from the date of such change, and submit the following supporting documents. A. In case of change of partners, the amended articles of partnership, and biodata, pictures, NBI clearances, AARB clearances, and income tax returns with proof of payment, for the last 2 years of the new partners. And B. In case of election of new members of the board of directors, the amended general information sheet and the biodata, pictures, NBI clearances, AARB clearances, and income tax returns with proof of payment for the last 2 years of the new directors. In case of change in the controlling shares, or composition of the board of directors or partnership, or any transfer of control in the operations of a licensed recruitment agency, the new set of board of directors or partners shall be subject to a panel interview, to ascertain their qualifications as provided in these rules. Section 26. Transfer of shares of stocks. A licensed recruitment agency operating as a corporation, shall notify the administration of any transfer of shares of stocks of the corporation, within 30 calendar days from approval of such transfer by SEC, together with the updated general information sheet reflecting such transfer, and a certified true copy of the stock and transfer book. Section 27. Appointment, termination, or resignation of officers and personnel. The licensed recruitment agency shall notify the administration of the appointment, termination or resignation of any officer and personnel of the agency, within 30 days from such appointment, termination or resignation. In case of appointment, the notification shall include the following documents. A. Letter of appointment containing duties and responsibilities duly accepted by the appointee. B. NBI and AIRB clearances. And C. Biodata and 2 recent passport size pictures. Section 28. Transfer of business address. A licensed recruitment agency may transfer its business address upon submission of the following. A. Letter of intent to transfer office in the case of sole proprietorship, or a partnership or board resolution approving the transfer of office in case of a partnership or a corporation. And B. Copy of lease contract, or proof of building ownership. The administration shall acknowledge such transfer after an assessment of compliance with space, office layout and equipment requirements has been completed. The licensed recruitment agency shall publish a notice to the public of the new business address in a newspaper of general circulation within 30 days from such transfer. The proof of publication shall be provided to the administration within 5 days from publication. Section 29. Establishment of a branch. A licensed recruitment agency may request for an authority to establish a branch, specifying the location, area and personnel. In case of a corporation, a board resolution authorizing the establishment of a branch shall be submitted. The request shall be subject to evaluation, taking into account the track record of the agency, and the number of job orders. Section 30. Additional office space. A licensed recruitment agency shall report to the administration the acquisition of additional office space. The additional office space shall be adjacent to the registered main office, or within the same building, provided that it is properly identified and covered by a duly notarized lease contract. Rule 3. Overseas Employment and Labor Laws Compliance System. Section 31. Assessment of Agencies and Labor Laws Compliance. The administration, in coordination with DOLE, shall assess, validate and monitor compliance of licensed recruitment agencies with these rules and applicable labor laws and social legislation. An assessment shall refer to the process of evaluating compliance with these rules, labor laws and social legislation, undertaken by qualified labor laws compliance officers or LLCOs, using a prescribed checklist, in accordance with the pertinent provisions of the Rules on Labor Laws Compliance System or LLCs, issued by the Secretary of Labor and Employment through Department Order No. 131-13. The assessment shall include matters relating to the maintenance of requirements on capitalization or equity, office space, equipment, facilities, and postings. The assessment shall be conducted prior to the issuance of a license, on post-qualification assessment, upgrading of provisional license to a regular license, issuance of branch authority, renewal of license and branch authority, and transfer of office. The assessment shall likewise be conducted once every 2 years after renewal of license. A. Assessment prior to the issuance of a license. Post-qualification assessment. Section 32. Scope of assessment. The post-qualification assessment shall cover compliance with minimum office space, facilities and equipment, under Section 9 hereof by the applicant, whose license application has been approved. The assessment shall be conducted prior to the issuance of the provisional license. Section 33. Issuance of authority to assess. The Licensing Regulations Office or LRO Director or his or her authorized representative, shall issue the authority to assess, indicating the names of the LLCO or POEA personnel, the applicant and its registered address, the purpose of the assessment and the validity period of the authority. Section 34. Conduct and Report of Assessment. The LLCO or POEA personnel shall proceed to the establishment and present the authority to the applicant agency. A responsible representative of the applicant shall receive and sign a copy of the authority. The assessment shall be conducted in the presence of such representative. The assessment report shall be forwarded to the licensing branch of the administration. B. Regular assessment. Section 35. Scope of regular assessment. The assessment shall be undertaken, as a requirement for upgrading of the provisional license to a regular license, renewal of license and branch authority, transfer of office, and once every 2 years after renewal of license. The assessment shall cover the following. A. Maintenance of the minimum office space, facilities and equipment. B. Maintenance of the required signs and postings, such as POEA door sticker, agency license, organizational chart, kaukulang bayad poster and anti-illegal recruitment campaign posters. C. Examination of books of accounts, official receipts, and financial statements. And D. Compliance with general labor standards, and occupational safety and health standards. Section 36. Issuance of authority to assess. The LRO director or his or her duly authorized representative shall issue the authority to assess to its duly authorized LLCOs, indicating the names of the LLCOs, the licensed recruitment agency to be assessed, the purpose of the assessment, and the validity period of the authority. The LRO director or his or her duly authorized representative may also request the Dole Regional Director for the conduct of assessment of licensed recruitment agencies, including their branches. Section 37. Conduct and Report of Assessment. The LLCO shall proceed to the establishment and present the authority to the licensed recruitment agency. A responsible representative of the licensed recruitment agency shall receive and sign a copy of the authority. The assessment shall be conducted in his or her presence, including a representative designated by the rank and file employees at the time of assessment. The assessment shall proceed, based on the assessment checklist contained in Annex A hereof. Section 38. Issuance of Notice of Results. The LLCO shall issue the Notice of Results, indicating compliance or deficiencies with POEA rules, labor laws and social legislation. The licensed recruitment agency representative shall acknowledge such results. Section 39. Report of Assessment. The LLCO shall endorse to the LRO Director the results relating to overseas employment, or to the Dole Regional Director for general labor standards and occupational safety and health standards. Section 40. Issuance of Certificate of Compliance. Licensed recruitment agencies that have complied with overseas employment rules and regulations shall be issued, within 5 days from such compliance, a certificate of compliance with a validity period of 2 years by the POEA administrator. The certificate of compliance with general labor standards and occupational safety and health shall be issued by the Dole Regional Director, who has territorial jurisdiction over the establishment. The certificate of compliance issued to a licensed recruitment agency shall cover branch offices that have been included in the renewal of license. Section 41. Compliance with deficiencies. In case of non-compliance, the LLCO shall issue a notice of results, together with the accomplished assessment checklist indicating the deficiencies. The licensed recruitment agency shall comply with the deficiencies or findings in accordance with the following. A. In case of deficiencies on office facilities, equipment, postings and signs, the agency shall, within 5 working days from the date of assessment, correct the deficiencies and submit proof of compliance for verification. Failure to comply shall cause the imposition of suspension of documentary processing, until compliance. B. For failure to maintain the required minimum office space, the agency shall submit proof of compliance within 30 days from assessment. Failure to comply, shall cause the imposition of suspension of documentary processing, until compliance. C. In case the audited financial statement indicates an amount lower than the required capitalization, the agency shall, within 30 days from the date of assessment, infuse additional capital up to the required minimum level, and submit the certificate of corporate filing or information on the present paid-up capital issued by the SEC. Failure to comply, shall cause the suspension of license, until compliance. D. In case of non-presentation of the books of accounts and official receipts during assessment, the agency shall be given 48 hours to present such books and receipts. Otherwise, a suspension of documentary processing, shall be imposed. E. If an unauthorized person is present in the agency's premises, the LLCO, shall report such findings for review and endorsement to the Adjudication Office for administrative proceedings. In case of deficiencies on general labor standards, and occupation safety and health standards, the DOLE shall have jurisdiction over the agency's compliance, in accordance with the rules on LLCs. C. Salvo or spot inspection. Section 42. Scope of salvo or spot inspection. The administration shall undertake inspection, in response to a complaint or report of illegal recruitment activities, and recruitment violations. Such inspection shall be conducted in accordance with the POEA Labor Laws Compliance Manual. Rule 4. Licensing of companies registered with Philippine Overseas Construction Board or POCB. Section 43. Licensing of POCB registered companies. POCB registered companies with overseas projects may apply in writing for a special license to deploy their workers to their overseas projects, subject to submission of the following requirements. A. Articles of incorporation. B. A certified true copy of the POCB certificate of registration. C. POCB certification of an existing overseas project. D. Affidavit of undertaking that the company will submit the renewed POCB registration upon its expiration. And E. Proof of payment of the non-refundable filing fee of 25,000 pesos. Section 44. Payment of fees. Upon approval of the application, the applicant shall A. Pay a license fee of 50,000 pesos. And B. Submit an escrow deposit agreement of 250,000 pesos with an accredited bank authorized to handle trust accounts by the Bangko Sentral ng Pilipinas. Section 45. Issuance of special license. The administration shall issue a special license to the POCB registered companies within 24 hours from receipt of application, provided all the requirements are met by the applicant. Only applications with complete supporting documents shall be deemed filed. Section 46. Validity period of special license. The special license shall be valid for 4 years from date of issuance, subject to the validity of the POCB registration, or unless sooner revoked, terminated, suspended, or cancelled by the Secretary or his or her duly authorized representative. Section 47. Requisites for renewal. Within 3 months prior to the expiration of the license, the POCB registered company shall submit a written application, together with the following requirements. A. Certified copy of valid POCB certificate of registration. B. Bank certificate, indicating that the escrow of 250,000 pesos is still intact. C. POCB certification of an existing overseas project. And D. Proof of payment of license fee of 50,000 pesos. Section 48. Prohibition on collection of fees from overseas Filipino workers. POCB registered companies shall not collect any fee from the workers deployed to their projects overseas. Section 49. POCB registered companies without overseas projects. POCB registered companies without POCB certified overseas projects, that intend to deploy workers overseas, may apply for a regular license pursuant to Rule 2, Part 2 of these rules. Rule 5. Fees, costs, and contributions. Section 50. Fees and costs chargeable to the overseas Filipino workers. The overseas Filipino worker shall pay the following fees and costs. A. Documentation costs. 1. Passport. 2. NBI or police or barangay clearance. 3. NSO authenticated birth certificate. 4. Transcript of records and diploma issued by the school, certified by the CHED and authenticated by the DFA. 5. Professional license issued by the PRC, authenticated by the DFA. 6. Certificate of competency issued by TESDA or other competent certifying body for the job applied for. And 7. DOH prescribed medical or health examination, based on the host country medical protocol. B. Membership with PhilHealth, POCB and the Social Security System. Section 51. Placement fee. A placement fee may be charged against the overseas Filipino worker, equivalent to 1 month basic salary, specified in the POEA approved contract, except for the following. A. Domestic workers. And B. Workers to be deployed to countries, where the prevailing system, either by law, policy or practice do not allow, directly or indirectly, the charging and collection of recruitment or placement fee. The worker shall pay the placement fee to the licensed recruitment agency, only after signing the POEA approved contract. The agency must issue a BIR registered receipt, stating the date of payment and the exact amount paid. Section 52. Payment of insurance premium. The licensed recruitment agency shall be responsible for the payment of the premium for the compulsory insurance coverage under Section 37A of RA 8042, as amended. Section 53. Costs and fees chargeable against the principal or employer. The cost of recruitment and placement shall be the responsibility of principal or employer, which cover payment for the following. A. Visa, including the stamping fee. B. Work permit and residence permit. C. Round-trip airfare. D. Transportation from the airport to the job site. E. POEA processing fee. F. OA membership fee. G. Additional trade test or assessment, if required by the principal or employer. Section 54. Prohibition against charging of other fees. No other charges in whatever amount, form, manner or purpose, shall be charged against the overseas Filipino worker, except those specified in this rule. Section 55. Service fees. Licensed recruitment agencies shall charge principals or employers service fees commensurate to the fair market value of their services. Rule 6. Skills test and medical examination for overseas employment. Section 56. Skills testing for applicant. An applicant for overseas employment shall undergo a skills test in a TESDA accredited skills testing center, only after the licensed recruitment agency and/or its principal or employer has pre-qualified him or her for work covered by an approved job order. The licensed recruitment agency shall ensure that the appropriate skills test shall be administered to the worker, corresponding to the position or job category applied for. Section 57. Medical or health examination. The licensed recruitment agency shall require an applicant to undergo a medical or health examination, as required by the medical protocol of the host country. The medical examination shall be conducted through a DOH accredited medical clinic of his or her choice, and only after reasonable certainty that the worker shall be hired by the principal or employer under an approved job order. The licensed recruitment agency shall ensure that the coverage of medical examination is in accordance with the standard requirements of the host government and the principal or employer. Rule 7. Recruitment outside registered office. Section 58. Special recruitment activity. A licensed recruitment agency may conduct recruitment activities outside its registered address, by securing a special recruitment authority, prior to the conduct of the recruitment. Section 59. Requirements for the issuance of special recruitment authority. A special recruitment authority or SRA, may be issued upon submission of the following requirements. A. Letter request from the agency, stating the exact date and venue of the special recruitment activity, as well as the names of the designated representatives. B. List of accredited principals or employers with sufficient job order balance. C. Proof of notice to the local government unit, through the Public Employment Service Office or PESO. And D. An undertaking that the agency shall take full responsibility for the acts of its representative officers and employees, and or the employer or his or her authorized representative. Section 60. Filing of application. An application for issuance of SRA shall be filed at least 3 days prior to the date of the activity, with any of the following POEA offices. A. POEA Central Office. B. POEA Regional Center or Regional Extension Unit or RU, under whose area of jurisdiction the agency is located. Or C. POEA Regional Center or RU under whose area of jurisdiction the special recruitment activity will be conducted. Section 61. Validity of SRA. The SRA shall be valid for the date and venue as indicated, unless extended, modified or revoked by the administration for violation of the conditions for its issuance. Section 62. Letter of Authority or LOA. The licensed recruitment agency shall notify the administration of the participation of an accredited principal or employer, or its registered or authorized representative in a recruitment activity, within its registered office, within 3 days prior to the activity. If the accredited principal or employer, or its registered authorized representative, shall participate in a recruitment activity outside its registered office, the application for LOA shall be filed at least 3 days prior to the date of the activity. Section 63. Venue and supervision of special recruitment activities. Recruitment activities outside the registered office of the licensed recruitment agency shall be conducted only at venues indicated in the authority, and shall be supervised by the administration, in coordination with the DOLE or PESO. Section 64. Terminal reports. A terminal report shall be submitted to the POEA office, which issued the SRA within 10 days, and a progress deployment report within 90 days after the activity. No subsequent SRA shall be issued until the licensed recruitment agency has submitted the required reports. Section 65. Participation in jobs fair. A licensed recruitment agency may participate in a jobs fair, and conduct recruitment activities based on POEA approved job orders, provided that a corresponding DOLE permit has been issued to the organizer of the jobs fair. Prior written notification which includes a list of authorized representatives who will be participating in the jobs fair, including the venue, date, and list of principals or employers, shall be submitted to the administration for monitoring and supervision. If the jobs fair is being organized by the PESO, no such permit shall be required, except for the prior notification requirement as mentioned above. Section 66. Cancellation of SRA or LOA. The administration reserves the right to cancel the SRA or LOA for violation of the conditions set therein. Rule 8. Advertisement for overseas job vacancies. Section 67. Advertisement for overseas employment. Advertisement for overseas employment shall include the publication of job vacancies in any form of communication, such as press releases, printed materials, or advertisements in radio, television, cinemas, internet, social media and other electronic forms, billboards, moving and human advertisements, and ad boards. Section 68. Advertisement of job vacancies with approved job orders. Licensed recruitment agencies may advertise job vacancies covered by approved job orders of accredited principals or employers, without prior approval from the administration, and within the validity of its accreditation. The advertisement shall indicate the following information. A. Name, address and POEA license number of the agency. B. Name, address, POEA registration or accreditation number, and worksite of the accredited principal or employer. C. Skill categories and qualification standards. And D. Number of available positions, and salaries net of foreign income tax. Section 69. Advertisement for manpower pooling. Licensed recruitment agencies may advertise for manpower pooling, subject to prior approval of the administration, and compliance with the following conditions. A. The advertisement shall indicate the phrases for manpower pooling only, no fees in any form and or purpose will be collected from the applicants, and beware of illegal recruiters and human traffickers, using large font in the advertisement. And B. The advertisement shall specify the name, address and POEA license number of the agency, name and worksite of the prospective or accredited principal or employer, and the skill categories and qualification standards. Section 70. Advertisement for overseas job vacancies by principals or employers. Accredited principals or employers may advertise overseas job vacancies, only through POEA licensed recruitment agencies, or through the administration. Section 71. Monitoring of advertisements. The administration shall monitor all advertisements, and non-compliant advertisements are considered as recruitment violations, which shall be penalized in accordance with a schedule of offenses and penalties. Rule 9. Departure and arrival of overseas Filipino workers. Section 72. Departure of workers. All departing overseas Filipino workers shall present their OECs to the immigration officer. For this purpose, the administration, in coordination with the Bureau of Immigration, shall establish a one-stop validation procedure and all exit points for all departing overseas Filipino workers. In the absence of the one-stop validation procedure, overseas Filipino workers shall present their OECs to the POEA, LAC. Section 73. Issuance of OEC at LAC. The administration may issue OEC at the LAC only to the following. A. Workers on special or emergency leave. And B. Cabin crew or flight attendants. Section 74. Lost OEC. In case of a lost OEC, Overseas Filipino workers may request in writing a certification from the LAC or the administration, stating that the worker has been issued OEC and specifying the details of the lost OEC. Section 75. Arrival of overseas Filipino workers. The administration, through the LAC, shall support OEA and other government agencies in providing assistance to arriving overseas Filipino workers, particularly those who are in distress. Rule 10. Illegal recruitment. Section 76. Acts constituting illegal recruitment. Illegal recruitment shall mean any act of canvassing, enlisting, contracting, transporting, utilizing, hiring or procuring workers and includes referrals, contract services, promising or advertising for employment abroad, whether for profit or not, when undertaken by a non-licensee or non-holder of authority contemplated under Article 13F, of Presidential Decree No. 442, as amended, otherwise known as the Labor Code of the Philippines. Provided that any such non-licensee or non-holder who, in any manner, offers or promises for a fee, employment abroad to 2 or more persons shall be deemed so engaged. It shall likewise include the following prohibited acts, committed by any person whether or not a licensee or a holder of authority. A. To charge, or accept directly or indirectly, any amount greater than that specified in the schedule of allowable fees prescribed by the Secretary, or to make a worker pay the recruiter or its agents, or acknowledge any amount greater than that actually loaned or advanced to him. B. To furnish or publish any false notice or information or document, in relation to recruitment or employment. C. To give any false notice, testimony, information or document, or commit any act of misrepresentation, for the purpose of securing a license or authority under the Labor Code. D. To give any false notice, testimony, information or document, or commit any act of misrepresentation, for the purpose of documenting hired workers with the POEA, which include the act of reprocessing workers through a job order that pertains to non-existent work, work different from the actual overseas work, or work with a different employer whether registered or not with the POEA. E. To induce or attempt to induce a worker already employed, to quit his or her employment, in order to offer him another, unless the transfer is designed to liberate a worker from oppressive terms and conditions of employment. F. To influence or attempt to influence any person or entity, not to employ any worker who has not applied for employment through his or her agency, or who has formed, joined or supported, or has contacted or is supported by any union or workers' organization. G. To engage in the recruitment or placement of workers, in jobs harmful to public health, or morality, or to the dignity of the Republic of the Philippines, as may be prohibited by law or duly constituted authority. H. To obstruct or attempt to obstruct inspection by the Secretary, or by his or her duly authorized representative. I. To fail to submit reports on the status of employment, placement vacancies, remittance of foreign exchange earnings, separation from jobs, departures and such other matters or information, as may be required by the Secretary under penalty of law. J. To substitute or alter to the prejudice of the worker, employment contract approved and verified by the DOLE, from the time of actual signing thereof by the parties, up to and including the period of the expiration of the same without the approval of the DOLE. K. For an officer or agent of a recruitment or placement agency, to become an officer or member of the board of any corporation engaged in travel agency, or insurance agency, or to be engaged directly or indirectly in the management of a travel agency or insurance agency. L. To withhold or deny travel documents from applicant workers before departure, for monetary or financial considerations, or for any other reasons, other than those authorized under the Labor Code and its implementing rules and regulations. M. To fail to actually deploy a contracted worker without valid reason as determined by the DOLE. N. To fail to reimburse expenses incurred by the worker in connection with his or her documentation and processing for purposes of deployment, in cases where the deployment does not actually take place without the worker's fault. O. To allow a non-Filipino citizen to head or manage a recruitment agency. P. To arrange, facilitate or grant a loan to an overseas Filipino worker, with interest exceeding 8% per annum, which will be used for payment of legal and allowable placement fees, and make the migrant worker issue, either personally or through a guarantor or accommodation party, post-dated checks in relation to the said loan. Q. To impose a compulsory and exclusive arrangement, whereby an overseas Filipino worker is required to avail of a loan, only from specifically designated institutions, entities or persons. R. To refuse to condone or renegotiate a loan incurred by an overseas Filipino worker, after the latter's employment contract has been prematurely terminated through no fault of his or her own. S. To impose a compulsory and exclusive arrangement, whereby an overseas Filipino worker is required to undergo health examinations only from specifically designated medical clinics, institutions, entities or persons, except in the case of a worker whose medical examination cost is shouldered by the principal. T. To impose a compulsory and exclusive arrangement, whereby an overseas Filipino worker is required to undergo training, seminar, instruction or schooling of any kind, only from specifically designated institutions, entities or persons, except for recommendatory trainings mandated by principals where the latter shoulder the cost of such trainings. U. For a suspended recruitment agency, to engage in any kind of recruitment activity, including the processing of pending workers' applications. And V. For a recruitment agency or a foreign principal or employer, to pass on to the overseas Filipino worker, or deduct from his or her salary, the payment of the cost of insurance fees, premium or other insurance-related charges, as provided under the compulsory workers' insurance coverage. Section 77. Independent Administrative Action. The institution of criminal action is without prejudice to any administrative action against the licensee, or holder of authority cognizable by the administration, which could proceed independently of the criminal action. Rule 11. Legal assistance and enforcement measures. Section 78. Anti-illegal recruitment and anti-trafficking in persons programs. The administration shall adopt policies and procedures, prepare and implement programs toward the eradication of illegal recruitment and trafficking in persons, committed by means of, or in the guise of recruitment for overseas employment such as, but not limited to the following. A. Legal assistance and counseling to victims on criminal and/or administrative actions. B. Investigation and conduct of operations, such as surveillance of persons and entities, closure of establishment, and assistance during entrapment or arrest. C. Prosecution, including legal assistance to victims during preliminary investigation and during trial, in collaboration with the prosecutors of the Department of Justice. And D. Information and education campaign, on overseas employment and anti-illegal recruitment and anti-trafficking in persons. Whenever necessary, the administration shall coordinate with other appropriate entities in the implementation of said programs. Section 79. Anti-Illegal Recruitment Fund. The administration shall establish an anti-illegal recruitment fund, to support victims of illegal recruitment and trafficking in persons during investigation and prosecution, and for other anti-illegal recruitment and anti-trafficking in persons programs. In furtherance of this objective, the administration may enter into partnerships with the private sector, local or international organizations and other government agencies. Section 80. Receiving complaints. Victims of illegal recruitment or trafficking in persons, involving recruitment for overseas employment and related cases, may report or file a complaint with the DOLE or its regional offices, or the administration or its regional centers or extension units. Section 81. Action on the complaint or report. Where the complaint or report alleges that illegal recruitment and/or trafficking in persons involving recruitment for overseas employment are ongoing, and such activities are confirmed in the preliminary examination of the complainants and the witnesses, or through the conduct of surveillance, the Director of the Licensing and Regulation Office or Director LRO, shall recommend to the Administrator the issuance of a closure order. Section 82. Surveillance. The administrator and/or designated official in the DOLE regional offices may, on his or her own initiative, conduct surveillance on the alleged illegal recruitment activities and trafficking in persons involving recruitment for overseas employment. Within 2 days from the termination of surveillance, a report supported by an affidavit shall be submitted to the Director LRO or the DOLE regional director concerned, as the case may be. Section 83. Issuance of closure order. The Secretary, or the Administrator, or the DOLE regional director of the appropriate regional office outside the National Capital Region, or their duly authorized representatives, may conduct an ex parte preliminary examination to determine whether the activities of a non-licensee violate existing laws, or constitute a danger to national security and public order, or will lead to further exploitation of job seekers. The Secretary, the Administrator, or the DOLE regional director concerned, or their duly authorized representatives, may also examine personally the complainants and/or their witnesses, in the form of searching questions and answers, and shall take their testimony under oath. The testimony of the complainants and/or witnesses, shall be reduced in writing and signed by them. If upon the preliminary examination or surveillance, the Secretary, the Administrator or DOLE regional director is satisfied that there is a violation of the law, or such danger or exploitation exists, a written order shall be issued for the closure of the establishment. Section 84. Implementation of closure order. The closure order shall be served upon the offender, or the person in charge of the establishment subject thereof. The closure shall be effected, by sealing and padlocking the establishment, and posting a notice of such closure in bold letters, in a conspicuous place in the premises of the establishment. Whenever necessary, the assistance and support of the appropriate law enforcement agencies may be requested for this purpose. The Secretary, the Administrator or the DOLE regional director concerned, shall recommend the immediate cancellation or revocation of the business permit, to the local government unit where such establishment operates. Section 85. Effect of closure order. All officers and employees of the entity responsible for the illegal recruitment activity, shall be ordered included in the list of persons with derogatory records, as provided in Section 3, and will be disqualified from participating in the overseas employment program of the government. Section 86. Report on implementation. A report on the implementation of the closure order executed under oath, shall be submitted to the LRO Director, or the DOLE regional director concerned, as the case may be, within 2 days from the date of implementation. Section 87. Institution of criminal action. The Secretary, the Administrator or the DOLE regional director concerned, or their duly authorized representatives, or any aggrieved person, may initiate the corresponding criminal action. Where a complaint is filed with the administration, and the same is proper for preliminary investigation, it shall endorse the corresponding complaint and supporting documents to the proper prosecution office. Section 88. Who may file a motion to reopen establishment? The motion to reopen may be filed only by the following: A. The owner of the building, or his or her duly authorized representative. B. the building administrator, or his or her duly authorized representative. C. The persons or entity against whom the closure order was issued, or the duly authorized representative. Or D. Any other person or entity legitimately operating within the premises closed or padlocked, and whose operations or activities are distinct from the recruitment activities of the person or entity subject of the closure order. Section 89. Grounds for reopening the establishment. An establishment which has been closed by the administration, may be reopened on the following grounds. A. The office is not the subject of the closure order. B. The contract of lease with the owner of the building or the building administrator, has already been cancelled or terminated. The request to reopen shall be duly supported by an affidavit of undertaking, either of the owner of the building or the building administrator, that the same will not be leased or rented to any other person or entity for recruitment purposes without a license. Or C. The office is shared by a person or entity not involved in illegal recruitment activities, whether directly or indirectly. Section 90. Motion to lift a closure order. A motion to lift a closure order, may be entertained only, when it is verified and filed by the person or entity against whom the closure order was issued or its duly authorized representative, with the LRO or the DOLE regional director, within 10 calendar days from the date of implementation thereof. The motion shall clearly state the ground or grounds upon which it is based, attaching thereto the documents in support thereof. A motion to lift which does not comply with the requirements herein set forth shall be denied. Section 91. Grounds for lifting a closure order. The lifting of the closure order may be granted, when the person or entity has proven that it is not involved in illegal recruitment activities, whether directly or indirectly. The lifting of the closure order, shall include the removal of the entity and the names of the persons from the list of persons with derogatory record. The lifting of a closure order is, however, without prejudice to filing of criminal action with the appropriate office, against any other person alleged to have conducted illegal recruitment activities, that led to the issuance of the closure order. Section 92. Appeal. The order of the administrator denying the motion to lift a closure order, or motion to reopen, may be appealed to the Secretary within 10 days from the service or receipt thereof. Any motion filed on the denial of a motion to lift, shall be treated as an appeal. Section 93. Repadlocking of office. The administration shall monitor establishments that are subject of closure orders. Where a reopened office is subsequently confirmed as still being used for illegal recruitment activities, a new closure order shall be issued, which shall no longer be subject to a motion to lift. Section 94. Prohibition on the use of establishment or space subject of a closure order. The establishment or space subject of an existing closure order, shall not be used for any purpose. Violation of this section shall be dealt with accordingly. Part 3. Placement by the private sector. Rule 1. Accreditation and registration of principals or employers. Section 95. Accreditation of principals or employers. The administration shall accredit principals or employers. This authority may be delegated to the POEA in countries or territories where it has jurisdiction. In this regard, the following rules shall govern. A. All documents for accreditation shall be verified by the POEA. B. In the absence of the POEA, the documents shall be duly authenticated by the Philippine Embassy or Consulate which has jurisdiction over the job site. C. In cases where there is no Philippine Embassy or Consulate in the job site, the principal or employer may submit the documents to the administration for attestation. For this purpose, verification shall refer to the procedure being conducted or applied by the labor attaché, to ensure that all the employment rights, benefits and welfare of Filipino migrant workers at the worksite are duly protected. The labor attaché shall also ensure that the employment contracts of overseas Filipino workers are consistent with the prevailing employment laws, standards and practices, in both the Philippines and the host country, and that the documentary requirements for overseas employment as required by the administration are complied with. Section 96. Requirements for accreditation of the principal or employer. The following are the requirements for accreditation of the principal or employer. A. General requirements. 1. Recruitment agreement. 2. Job order indicating the positions, the number of positions required and salary per position. 3. Copy of valid commercial registration and business license of the principal, issued and authenticated by the Chamber of Commerce or a relevant government office, including information on business activities, number of years in operation, and volume or size of current labor force. 4. Master employment contract, signed on all pages by the principal or his or her authorized representative. And 5. Contingency plan as may be applicable. B. Additional requirements. B. 1. For foreign placement agencies. 1. Business license, or valid commercial registration of the actual employer hiring skilled overseas Filipino workers. 2. Master employment contract from the employer, signed jointly in all pages by the FPA and the actual employer or his or her authorized representative. 3. Manpower request from the employer. 4. Service agreement between the FPA and the client or employer. 5. FPAs hiring domestic workers, shall be required to put up an escrow account, with a bank authorized by the Bangko Sentral ng Pilipinas to handle trust accounts, with deposit in the amount of 50,000 United States dollars. The escrow deposit shall answer for all valid and legal claims, arising from violations of contracts of employment. And 6. Undertaking by the FPA or employer, to monitor the employment of overseas Filipino workers and to submit a report of significant incidents relative thereto. B. 2. For staffing or sourcing company. 1. The list of names and addresses of its clients. 2. Manpower request from the client. And 3. Service agreement between the company and its clients. Section 97. Issuance of accreditation certificate. The administration or POLO shall issue, upon full compliance with the requirements, a certificate of accreditation duly signed by an authorized officer, which shall contain the following information. A. Name of the employer or company. B. Complete business address, email address, contact number. C. Name of authorized representative. D. Validity period. And E. Date of issuance. Section 98. Registration of principal or employer. The POEA shall register a principal or employer duly accredited by the POLO, upon submission of the certificate of accreditation by the POLO, including the supporting documents. Section 99. Registration of POCB registered projects. The administration shall register POCB registered projects upon submission of the following requirements. A. Project authorization from POCB, including manpower requirement of the project, compensation, and mobilization schedule. And B. Master employment contract. Section 100. Validity of accreditation. The accreditation shall be valid for 4 years. Section 101. Suspension of accreditation by the POLO. The POLO may suspend accreditation based on any of the following grounds. A. Unjustified refusal to assist, or repatriate distressed overseas Filipino worker or workers. B. Deliberate violation or non-compliance of the principal or employer, with its contractual obligations to its hired overseas Filipino worker or workers. C. Continued processing and deployment of the overseas Filipino workers for the principal or employer, will lead to the further exploitation of any or all of its applicants and overseas Filipino workers, or pose imminent danger to the lives and safety of its overseas Filipino worker or workers. Or D. When found to have hired and employed an overseas Filipino worker, who is either a minor or below the prescribed minimum age requirement. Section 102. Procedures for suspension of accreditation. Upon receipt of the advice or complaint, or report of an alleged violation, the POLO shall require the principal or employer to comment in writing, within 2 days from receipt of the POLO advice, complaint or report. After evaluating the comment submitted by the principal or employer, and the POLO has determined that there exists a valid ground for suspension of accreditation, the POLO shall issue a notice of suspension. The suspension of accreditation may be imposed for a maximum period of 60 days, which may be lifted upon satisfactory settlement of overseas Filipino workers' claim or claims, or upon compliance with the conditions for lifting the suspension. The principal or employer may file an appeal from the denial of the lifting of the suspension, before the DOLE. The appeal shall be filed through the POLO, within 15 days from receipt of the denial. The POLO shall notify the administration of the suspension of the accreditation, imposed against the principal or employer. The POLO may also recommend the filing of a disciplinary action case against the principal or employer before the administration. If the case against the principal or employer is filed before the POEA, the procedure shall be governed by the rules on disciplinary action cases against a principal or employer. Section 103. Effect of suspension of accreditation by the POLO. The suspension of accreditation by the POLO shall have the effect of suspending the documentary processing of the principal or employer at the POLO in the administration. Section 104. Revocation of accreditation and registration. The POLO or the administration shall automatically revoke the accreditation of a principal or employer, on any of the following grounds. A. Expiration of the principal's or employer's business license, or cessation of business or recruitment activity, after a period of 1 year from expiration or cessation. B. Upon written mutual agreement by the principal or employer and the licensed recruitment agency to terminate the agreement. C. When the principal or employer is meted the penalty of disqualification from participation in the overseas employment program. And D. Failure to comply with the undertaking submitted as requirement for accreditation. Section 105. Procedure for revocation or cancellation of accreditation by the POLO. The following procedures shall apply in the revocation or cancellation of accreditation. A. Upon the existence of any of the foregoing grounds for revocation or cancellation of accreditation, the POLO shall verify or communicate with the principal or employer and licensed recruitment agency, and require them to submit their comments within a period of 5 days from receipt of the POLO notice. B. Upon receipt of the comments, the POLO shall evaluate the merits of the response of the principal or employer and licensed recruitment agency. Failure of the concerned parties to comment within the prescribed period, shall be construed as a waiver, and the POLO shall immediately proceed with the investigation based on the available records. And C. After evaluation of the comments and the available documents, the POLO shall render a decision. In case of revocation or cancellation of accreditation, the POLO shall immediately notify in writing the concerned parties and the administration. Section 106. Validity of manpower request or job order. Job orders approved by the administration shall be valid for a period of 2 years, subject to revalidation for another 2 years, upon confirmation of the principal or employer. Section 107. Renewal of accreditation. The accreditation may be renewed at the request of the principal or employer, or licensed recruitment agency, and upon submission of the following. A. Reconfirmed recruitment agreement. And B. Revalidated or new job order. Section 108. Dual or multiple accreditation of principal or employer. A principal which is a foreign placement agency, may be accredited to only 2 licensed recruitment agencies, while an employer may be accredited up to a maximum of 5 licensed recruitment agencies, provided that A. A uniform or upgraded compensation package shall be adopted by the principal or employer and the agencies, for the same project in the same job site. B. The principal or employer has a new job order of at least 100 workers, for the same project in the same job site, as verified by the POLO, or the principal, or employer must have hired and employed at least 100 workers, for the same project in the same job site, within a period of 1 year immediately preceding the request for dual or multiple registration or accreditation. And C. The principal or employer shall submit an undertaking, that it will comply with all its obligations to other licensed recruitment agencies to which it is currently accredited. Section 109. Transfer of accreditation. The accreditation of a principal or employer may be transferred to another licensed recruitment agency, provided that A. There is no downgrading of the compensation package adopted by the principal with the licensed recruitment agency, to which it is currently or previously accredited. B. The transferee agency shall assume full and complete responsibility for all contractual obligations of the principal or employer to the overseas Filipino workers originally recruited and deployed by the former licensed recruitment agency, by submitting to the POLO or to the administration, as the case may be, an undertaking to that effect. And C. The principal or employer must have no pending disciplinary action case. For this purpose, any accreditation, within 6 months immediately following its cancellation by the principal or employer, shall be deemed a transfer of accreditation. Section 110. Action on applications for transfer of accreditation of a principal or employer with outstanding obligations. Money claims or obligations arising out of their recruitment agreement, shall not prevent the POLO or the administration from acting on the request for registration or accreditation, if public interest so requires. Section 111. Accreditation of principal or employer, in countries covered by a special agreement. The accreditation of a principal or employer, in countries covered by any special agreement entered into by the Philippine government, shall be in accordance with guidelines prescribed by the administration. Section 112. Suspension of the authority of the POLO to accredit principal or employer. The authority granted to POLO by the POEA, to accredit principal or employer, may be suspended by the administrator, when there is evidence of persistent or habitual negligence resulting in erroneous accreditation on any of the following grounds. A. Accreditation which is not in compliance with the POEA rules and regulations on principal or employer accreditation. B. Non-compliance with established POLO verification procedures. Or C. Accreditation of a watch-listed principal or employer. The International Labor Affairs Bureau or ILAB DOLE, shall be duly notified of such suspension for its appropriate action. Section 113. Lifting of suspension. The administrator may, upon recommendation by the ILAB DOLE, reinstate the authority to accredit a principal or employer. Rule 2. Documentation and deployment of overseas Filipino workers. Section 114. Deployment of overseas Filipino workers. the state shall allow the deployment of overseas Filipino workers, only in countries, where the rights of overseas Filipino workers are protected. The government recognizes any of the following, as a guarantee on the part of the receiving country for the protection of the rights of overseas Filipino workers. A. It has existing labor and social laws protecting the rights of workers, including migrant workers. B. It is a signatory to, and/or ratifier of multilateral conventions, declarations or resolutions relating to the protection of workers including migrant workers. Or C. It has concluded a bilateral agreement or arrangement with the government on the protection of the rights of OFWs. Provided that, the receiving country is taking positive, concrete measures to protect the rights of workers, in furtherance of any of the guarantees under subparagraphs A, B, and C, hereof. The DFA, through its foreign posts, shall issue a certification to the administration, specifying therein the pertinent provisions of the receiving country's labor or social law, or the convention, declaration or resolution, or the bilateral agreement or arrangement which protect the rights of overseas Filipino workers. The administration, through a governing board resolution, shall allow the deployment of overseas Filipino workers, only to countries certified by the DFA as compliant with the guarantees for the protection of the rights of overseas Filipino workers. Section 115. Deployment of overseas Filipino workers, to companies and contractors with international operations, in countries not certified by the DFA as compliant. The administration shall allow the deployment of overseas Filipino workers, to companies and contractors with international operations, in countries not certified by the DFA as compliant. Provided, such companies and contractors are compliant with standards, conditions and requirements, as embodied in the employment contracts prescribed by the administration, and in accordance with internationally accepted standards. Section 116. Ban or termination of deployment. Notwithstanding the provisions of the preceding sections, in pursuit of national interest, or when public welfare so requires, the POEA Governing Board may, after consultation with the DFA, at any time impose or terminate a ban on the deployment of overseas Filipino workers. The administration, based on reports, may recommend to the POEA Governing Board, a reduction in the deployment of overseas Filipino workers. Section 117. Documentary requirements for the processing of agency hires. The following documents shall be submitted for contract processing and documentation of new hires. A. Request for processing or RFP, using the POEA prescribed form, indicating the following. 1. Name of OFW, 2. Position, 3. Salary, 4. Contract duration, 5. Job site, 6. Particulars of certificate of cover of mandatory insurance, and 7. Name of principal based on the POEA approved master employment contract. B. Passport valid at least 6 months from the intended date of departure, C. Valid and appropriate visa, D. Individual verified employment contracts for low or semi-skilled workers, E. One-page summary of the contract for other highly skilled and professional overseas Filipino workers, containing the following basic contract provisions. 1. Name, birthdate, and sex of the worker, 2. Name of employer, 3. Job site, 4. Position, 5. Basic salary, overtime pay, and allowances, 6. Food and accommodation, 7. Contract duration, and 8. Mandatory insurance provider and certificate of cover or policy number. F. Pre-employment orientation seminar or POS and pre-departure orientation seminar or POS certificates, G. Certificate of medical fitness issued by DOH accredited medical clinics for OFWs, H. Educational attainment, and I. TESDA skill certification. Section 118. Documentary requirements for the processing of domestic worker. The following documents shall be submitted for contract processing and documentation of newly hired domestic workers. A. Request for processing or RFP using POEA prescribed form indicating the following: 1. Name of OFW, 2. Position, 3. Salary, 4. Contract duration, 5. Job site, 6. Particulars of certificate of cover of mandatory insurance, and 7. Name of the foreign placement agency and the employer. B. Passport valid at least 6 months from the intended date of departure. C. Valid and appropriate visa. D. Individual verified employment contract. E. Pre-employment orientation seminar, pre-departure orientation seminar, and comprehensive pre-departure education program certificates. F. Certificate of medical fitness issued by DOH accredited medical clinics for OFWs, and G. TESDA skill certification. Section 119. Minimum age for deployment, and compensation of domestic worker. The minimum deployment age, and the minimum salary of a domestic worker shall be determined by the POEA Governing Board. Section 120. Issuance of Overseas Employment Certificate. An OEC shall be issued only upon compliance with the documentary requirements for contract processing, and payment of POEA processing fee and OA membership contribution. Section 121. Validity of Overseas Employment Certificate, and period to deploy. An OEC shall be valid for 60 days from date of issuance, within which period the licensed recruitment agency shall deploy its documented overseas Filipino workers. The licensed recruitment agency shall report to the administration within 15 days from the expiry date of the OEC, in case of non-deployment, and the reason or reasons therefor. In case of issuance of multiple OEC, its validity shall depend on contract duration. Section 122. Registration of returning overseas Filipino workers. A. The registration of the returning overseas Filipino workers as defined in these rules, shall be through online, or by submission of the following documents to the administration or to the POLOs for registration. 1. Passport valid at least 6 months from the date of intended departure. 2. Valid and appropriate visa or work permit, and 3. Certificate of insurance coverage, similar to the benefits provided under the mandatory insurance coverage contained in Section 37A of RA 8042, as amended, at the option of the overseas Filipino worker. B. For returning overseas Filipino workers who are not registered with the administration, or who changed employers on site, the following additional requirements shall be required. 1. Proof of existing employment, such as payroll slip or valid company identification card. 2. Existing employment contract. 3. Affidavit stating the circumstances regarding the deployment, and 4. Certificate of insurance coverage, similar to the benefits provided under the mandatory insurance coverage contained in Section 37A, of RA 8042, as amended, at the option of the worker. C. In case of issuance of multiple OECs, its validity shall depend on contract duration. Section 123. Ban on direct hires. No employer shall directly hire an overseas Filipino worker for overseas employment. Section 124. Exemption from the ban on direct hiring. The following are exempted from the ban on direct hiring. A. Members of the Diplomatic Corps. B. International organizations. C. Heads of state and government officials, with the rank of at least Deputy Minister, or D. Other employers as may be allowed by the Secretary of Labor and Employment, such as 1. Those provided in A, B, and C, who bear a lesser rank, if endorsed by the Polo, or head of mission in the absence of the Polo. 2. Professionals and skilled workers with duly executed or authenticated contracts, containing terms and conditions over and above the standards set by the POEA. The number of professional and skilled overseas Filipino workers hired for the first time by the employer, shall not exceed 5. For the purpose of determining the number, workers hired as a group, shall be counted as one. Or 3. Workers hired by a relative, or family member who is a permanent resident of the host country. Section 125. Documentary requirements for registration of overseas Filipino workers hired by employers, who are exempted from the ban on direct hiring. The overseas Filipino workers, hired by those employers exempted from the ban on direct hiring, may be registered by the administration upon submission of the following documents. A. Verified or authenticated original employment contract, which is over and above the POEA prescribed employment contract. B. Passport valid at least 6 months from the date of intended departure. C. Valid and appropriate visa or work permit. D. Certificate of medical fitness. E. Proof of certificate of insurance coverage covering at least the benefits provided under Section 37A, of RA 8042, as amended. F. Certificate of attendance to the required employment orientation or briefing. And G. Clearance from the Secretary of Labor and Employment for those covered under Section 124D, of these rules. The administration shall ensure that the worker is made fully aware of the terms and conditions of the employment contract, and the advantages and disadvantages of direct hiring. Section 126. In-house processing facility. The administration shall develop and create a system for in-house processing, through electronic submission at the Land-Based Center for all agencies.